Has given you a lot of suggestions and ideas on how you can go back and organize your respective lawyers' files. Going on with the program, now that we have heard about confidentiality and organization, we'll get down to the nitty-gritties of doing some work and procedures. Time limits relevant to civil proceedings is the topic we've imposed upon Michael Royce. Mr. Royce is with a small firm known as McCarthy, someplace in downtown Toronto. He was called to the bar in 1973, and while his practice is in civil litigation, I'm told by good authority he does white-collar criminal work, defense of doctors, and I don't think the two go together, inquests, and administrative law. Michael Royce, please.
Put this on now.
On this side. I didn't hear you.
All right.
Thanks.
All right. Thanks very much, Adeline. This is an extraordinarily dull topic, and I'll do what I can to make it interesting. I apologize, of course, for the many typos. As you know, it's impossible to get a decent litigation secretary these days. I went through a better part of a Saturday morning about a month ago, sitting down with the white book that you're all familiar with, known as Chitties, and simply went through and picked out everything that had some kind of time limit in it, and came up with the not particularly innovative list that you have in front of you. I don't intend to go through all of them, although I think that you'll find it useful, because I think it's fair to say, E&OE, that every time limit in the white book with respect to the matters dealt with here is referred to. I have not dealt with execution procedures, because you're getting a separate lecture on that. I inadvertently dealt with appeal procedures, notwithstanding the fact you're getting a lecture on that. I got so interested I just couldn't stop. Now, let's just start with where you get the thing started. We're talking litigation, of course, at this point. We're starting about beginning an action. Let's just call it an action, even though it may begin with the issuance of a writ of summons, as most ordinary civil proceedings do. If it's a divorce action, it'll begin with issuing a notice of petition for divorce. Now, those are two separate documents, the writ of summons and the notice of petition for divorce, both of which are issued out of a court office, be it Supreme Court or county court, out of the court office. First thing to note, court office open 9:30 a.m., 4:30 p.m. They don't even like to answer the phone outside of those hours. Now, don't lose sight, please, of the old Kenora shuffle. If by chance you realize in a motor vehicle or something like that that the client has come in on the last day and your boss has got this damn writ typed up and we got to get it issued by 4:30 and it's like 4:25, don't bother. Get your lawyer's phone book, look up Kenora, different time zone, remember. Phone them, dictate to a secretary there the writ, and have them issue it there. You got an extra hour to play with, and it's the most important thing that I'm probably going to tell you today. Okay? And if you can't get a lawyer in Kenora, never lose sight of Fort Francis, same time zone. And it won't probably happen more than once in all of your joint lifetimes, but if it happens once, you've saved yourself and your lawyer a claim to Maltman's. And the lawyers there, I can tell you, are used to those kinds of calls, and you can just dictate the writ. They got all the forms the same as you do. They crank it out. One less Maltman claim. Okay, you issue the writ, and I don't know to what extent you people have to personally go. In our little Mickey Mouse firm, we have people who do such things, and they're not secretaries. But essentially, you go up there, and they put a big red seal on, and they keep a copy. They give it back to you, then got the writ or the notice of petition for divorce. That's how most actions start. However, there's a different way to start some kinds of proceedings called an originating notice of motion. You're all familiar, I assume, with notices of motion, but remember there are two distinct kinds. First of all, the originating notice of motion is with respect to certain kinds of proceedings authorized under statutes. And because they're authorized under statutes, it specifically says you can start it with an originating motion, and that starts an originating notice of motion. You serve the notice of motion, and it's service of the notice of motion that starts the time running. That is to say, you have started the proceeding as of the date of service of that, not the time you then file it. Service starts that. Everything else, the writ and the notice of petition for divorce, the issuance starts it. You then serve it. Two slightly different starting times for those. Okay, next fundamental point, I guess. What sorts of things have to be served personally upon the defendants or respondents named in the action, and what sorts of things can just be served on their lawyers or by mail? Well, as you'll see in Rule 16, any document which starts the action. The writ, notice of petition for divorce, originating notice of motion. That, generally speaking, has to be served personally. It's common sense. Up until that time, theoretically at least, the respondent or defendant doesn't know he or she is being sued. So it has to be served personally upon them. However, often in cases in which litigation ensues, there have been prior discussions between lawyers, in which case you will be, in many cases, able to arrange with the lawyer for the defendant or respondent to accept, magic word, accept service. Now, what is acceptance of service? What's the difference between that and admitting service? It's this. The lawyer who accepts service is accepting service of that original document in lieu of personal service. All right? He is saying something very important. He is representing that he or she has authority from his or her client to accept service in lieu of the document being served personally. This is something that you would never, ever do without your lawyer, and I'm speaking now to you as secretaries, expressly instructing you to, because you waive some very important rights of your client, or you may, by accepting service. For example, let's just take the case of the client, the respondent, or defendant who's out of the province. If you want to serve documents on somebody who does not reside or carry on business in Ontario, you have to fit within Rule 25. There's certain categories there. Otherwise, you can't validly serve. However, any objection, and there may even then be objections to service, which can validly be taken, or objections to the jurisdiction of an Ontario court, which can validly be taken. If, however, the defendant or respondent enters an appearance in response to any Ontario action, he or she or it is taken to have waived those objections. That's if they enter an appearance. The same thing applies if you accept service. If a lawyer in Ontario accepts service on behalf of a foreign party, he or she is waiving any objection on that party with respect to the right to be served. And that's something you would only do with instructions, because often you'll advise a foreign client, ignore the Ontario action. If you don't have assets up here, forget about it. So you would never accept service without express instructions. Admitting service we'll get to in a moment, but let me just touch on it now. Admitting service is with respect to all subsequent documents in the litigation, beyond the document that started the matter, that starts the matter. It does not have to be served personally. It can be served in a variety of ways, generally speaking, on the lawyer, assuming there is a lawyer who has entered an appearance and is on the record. It can be served on the lawyer. And it can be served simply by mail, as we'll get to, or just by going to the lawyer's office and getting added stamp admitting service. So acceptance of service you've got to be careful about. Admitting service is a more routine kind of thing, which is generally done unless you would be expressly instructed not to by the lawyer for some procedural reason. Okay, one other thing. While personal service is normally required of the starting document, and accepting service is a way around that, you sometimes, of course, can't find the more sophisticated kind of bandit who is evading service. That sort of person you then apply to the master's office of the county court judge for an order for substitutional service, okay, and that's covered under Rule 16. And you have to file an affidavit showing what efforts you made and so on, and why you couldn't serve him, and he's in there peeking through the door and giving you the finger and telling you he's not going to come out. So, that being so, you then put all that in an affidavit, you apply before the master of the county court judge. He will then normally make an order allowing you for substitutional service. If you know where the person is, then you can just put it through the mail slot, and that will be valid service in lieu of personal service. If you can't find the person at all, but you're pretty sure he's in Toronto, you can get often an order to serve by means of advertisements in papers, that sort of thing. Okay, that's the fundamental service provisions. Rule 25, as I say, deals with service outside of Ontario, and Rule 28 gives the time limits. Obviously, we're talking outside Ontario, so in the United States or any province other than Ontario, 40 days to enter an appearance. Outside Canada and the United States, 60 days. That's Rule 27. Or I'm sorry, Rule 28. The appearance to a generally endorsed writ of summons, of course, is within 10 days. But whether or not you enter an appearance really isn't very important. If there's no statement of claim in a generally endorsed writ type action, it really doesn't matter whether you do anything or not, because nowadays, they changed the rule some years ago, the plaintiff cannot, on a generally endorsed writ, do anything at all about the fact there's no appearance to it unless he's also served a statement of claim. It's only when the writ and the statement of claim are served that time effectively starts to run in a generally endorsed situation. You will, however, normally enter the appearance. Bear in mind, and just a little side note here, there are an awful lot of time limits set out in the rules, and we're going through them. Almost all of them you can ignore at your peril. Not all of them, but almost all of them you can ignore at your peril in the sense that unless the lawyer on the other side takes a positive step to note pleadings closed or some equivalent step, the court will still accept the document. For example, an appearance will readily be accepted long after 10 days, provided that no notice of pleadings have been noted closed, no judgment has been signed, no other steps being taken by the other side. So most of these things, while they say shall or must, don't in fact mean that they're mandatory. But what it does mean is that if you don't comply with it, you run the real risk that the lawyer on the other side will take steps to move the action ahead, and you and your lawyer and your client will be in trouble. So while it's not mandatory, you've got to make sure that as far as possible you do comply with them, because you never know what the lawyer on the other side is going to do. If you're going to have trouble complying with the time limit, get in touch immediately with the other side, tell them what your problem is, ask them not to take that next step, and they, I think, are duty-bound, as we now practice law, to tell you. And they may well have to say, I've got instructions to get this thing ahead, I'm sorry, I can't give you an extra 5 days to get your statement of defense in or anything like that. But absent that, I think you're entitled to assume that the other side will give you a reasonable period of time, but you've got to clear it with them. Don't just assume it, or you're going to get your tail in the gate, for sure. Okay, a statement of claim is the follow-up to a generally endorsed writ of summons. The specially endorsed writ of summons is a different thing. In that case, an appearance and an affidavit of merits, setting out a sworn defense of some mock or sham kind, usually, has to be filed within 15 days. And if it isn't filed within 15 days, the appearance and the affidavit of merits, the plaintiff can then just go to the court office and sign judgment, as it's called. And you'll never hear a word about it. They don't have to go in front of a judge or anything. They just sign judgment, and boom, they've got themselves a judgment, just like that. So a specially endorsed writ of summons, you've got to be very, very careful about. You've got to watch your time limits, the 15 days, very carefully. Make sure you get any necessary extensions from the other side if you think you're going to need them. If it's a generally endorsed writ of summons, you can serve, as I've said, just the writ of summons, but there really isn't much point in doing so in terms of serving it, unless you're running out of time and you still don't know enough to put together your statement of claim. Because, remember, first of all, the writ of summons has to be issued to start the action within whatever time limit there may be. Motor vehicles, it's 2 years. Medical matters, and often it's a year. There are a lot of other time limits like that. To issue it. You then have another year to serve it. Another year to serve it. And you would certainly hope that within that year you've got enough information to put together your statement of claim. Because you're wasting money, generally speaking, to go out and personally serve by a sheriff or special agent or whatever, just the writ, if it's generally endorsed, because it doesn't give you any rights. You've got to get the statement of claim issued and served as well, and normally that's what you will do. You will serve both documents together, the generally endorsed writ and the statement of claim. You must, in any event, deliver a statement of claim. If you've started the action with a writ, obviously you can deliver the statement of claim before any appearance comes in, that goes without saying, or within 30 days after the appearance comes in is when you're supposed to do it, all right? Or if there's more than one party to the action, and here there's a typo, Rule 43, can I correct it for you, please? Look at Rule 43 on page 14. Come down to the third line, or in fact, we'll read the whole thing. A plaintiff is required to deliver a statement of claim at any time before an appearance is filed or within 30 days thereafter, or where there is more than one defendant, within 90 days after, and you've got to add these words right after the word after the first appearance. So it's within 90 days after the first appearance or 30 days after, you've got to write all that in, the first appearance or 30 days after, and carrying on, after all defendants have appeared. So you've got 3 defendants, 1 issues an appearance promptly, 2 take a long time. You can wait until 30 days after the last appearance is in, but you don't know when the last appearance is going to come in. What can trigger it then is it's 30 days after the first appearance comes within 30 days after all are in, or 90 days maximum. That's the longest you're going to have to wait, is 90 days from the first appearance coming in. Now that's the time within which a statement of claim is to be delivered, and if it isn't, what happens? We're back to the original situation. Nothing automatically happens at all. But you as a defendant can then move, if you've been served and you put in an appearance and those time limits have passed, you can move to dismiss the action for want of prosecution. If you choose not to do that, nothing happens. The action just keeps on, and eventually a statement of claim, I suppose, will come in. But this is the kind of point I'm making. The time limits are there, and after they've expired, it's not that the action automatically dissolves in smoke. Rather, it's up to the other side, and the other side then has rights to do things to your prejudice. And if they're going to do things to your prejudice, You want to know in advance, and you want to be in a position to move quickly to get, in this case, the statement of claim in. Then we go on with the fact that a statement of defense, and a counterclaim if you're going to include that, has to be delivered within 20 days after the statement of claim. Again, nothing magic happens if the 20 days expires and you haven't got your statement of defense in, but if the other side wants to, thereafter, they can note pleadings closed and move against you. And that's the kind of problem that you can face in these sorts of things. It's what the other side is going to do to you, not what automatically happens. Moving on to the counterclaim, you're aware of the concept of a counterclaim. If a counterclaim is included in the statement of defense, then you have to deliver a reply and a defense to that counterclaim. And the defense to counterclaim, again, you have 20 days from the time the counterclaim is served on you. Again, it's one of these time limits that you want to do it, or because the other side may do something to you, but failing that, you can take longer than that. Rules 50 and 62 are important and often forgotten. Suppose that you have served a writ of summons and a statement of claim on somebody else. They may have entered an appearance, but they haven't filed a statement of defense. Now, after 20 days, you could move to note pleadings closed and move on for judgment. You could. But somehow you didn't get around it because, as you normally would, you allow them somewhat longer. And time kind of passes by. Your client hasn't pushed you very hard on it. You forget about it. And suddenly, a year and a half later, you think, gosh, I never got a statement of defense. I better thunder ahead and sign judgment, or rather, note pleadings closed and move for judgment. Well, you can't, because there's a 1 year within which you must move for default judgment on a specially endorsed writ. That is to say, if you haven't moved after the 15 days, there's no appearance in, you can sign judgment any time from 15 days being expired for the next year. But thereafter, if you leave it more than a year, you've got to move and get leave in court to do anything. And this can occasionally happen, where there's not a lot of urgency to it, and you kind of lose sight of it, and then you have to go and bring a motion. That's costing your client some money. So rules 50 and 62 are saying you've got to move for a default judgment. If you're going to move for it, do it within a year. Okay, pleadings on Rule 122 are deemed to be noted closed, or to be closed, as soon as the reply has been delivered, but a lot of people don't deliver replies these days, so it's in the alternative as soon as the time for delivering a reply has expired. That means, strictly speaking, a reply can't be delivered more than 10 days after the statement of defense. In fact, routinely people deliver replies past that time because, again, the court will accept them and nothing magic ensues unless the other side moves to strictly note pleadings closed. Amendments are dealt with in Rule 130, and it's one of the things that you've got to be aware of. Here is one of the areas you can get in trouble. Where there you obtain an order to amend a pleading, it will say, for example, you want to amend your statement of claim, it'll say that you should be at liberty to amend your statement of claim within 10 days, is often put. That is mandatory. If you don't comply with that where it's in an order, then the court office will not let you come in on the 11th day and say, right, here's my amended statement of claim, I want to make the changes on the original here. They won't let you do it, okay? So that's a mandatory one where it's in a court order. Equally, that order will also say within 10 days thereafter deliver a statement of defense, amended statement of defense, if so advised. The defense may. You've got to do it within the 10 days because the court simply won't accept it otherwise because it's in an order. It's not just in the rules, it's in an order. Watch out for that one. Section 60 of the Judicature Act says that if you want to deliver a jury notice, and that of course is a decision for the lawyer, it's got to be done no later than the 4th day after the close of pleadings. And we talked about when pleadings are deemed to be closed. What you'll normally do is deliver the jury notice. If you're the plaintiff, you're going to deliver it more or less the same time probably as your statement of claim. If you're the defendant, you'll deliver it with your statement of defense. Okay, then Rules 167 up through 171 deal with third-party proceedings. There are all kinds of time limits in them. I'm basically going to leave it to you because they're there and I think they're clear enough, and we're going through the time faster than I thought we would. Can I take you up to Rule 174? Rule 174 up through 179 has some general time type rules, and you've got to know them because they apply to all the different time limits that we're talking about. First of all, Rule 174 is important, where a period in the rules where it says less than 6 days, holidays don't count, but Saturdays do. Saturday is not deemed to be a holiday. Most of us no longer work Saturdays, but when these rules were drafted, law offices were always open on Saturday mornings. Nobody's bothered to change that, and thus Saturdays do count. Sundays don't count, holidays don't count. Holidays don't count, okay? So that's less than 6 days. You don't count Sundays and holidays, you do count Saturdays. Rule 175, though, says, next thing, where you're talking about clear days, and I should just say 174, of course, limiting to less than 6 days. If you're talking 6 days or more, you count all days, Sundays, holidays, everything. And on a long weekend in the middle and stuff, you can get caught on that. It can leave you with very few effective days in which to get things served and so on, if you're talking about a 3 or 4 day weekend. All right, Rule 175. Well, what do we mean by days? I mean, does it start as today count when I'm just sending the thing out? Does the day on which the motion is returnable count? Well, it's set out in 175, where it says in the rules, clear days, 10 clear days. That means just that. It means the 10 days in between the two things you're talking about. The service and the motion don't count. Neither of those 2 days count, just the in-between days. So if you're serving it on the 1st, you go the 1st, and then you go to the 2nd through to the 11th are going to be clear days, and so your motion is going to be the 12th. It's the earliest you're going to be able to bring it on. If you've got a 10 clear days. Clear days means just that. It doesn't include the day of service. It doesn't include the day on which whatever it is happening, the motion or whatever. Where we have the next thing, we have the days are clear days or at least. And at least is another way in which they do that, all right? That is the same thing. And again, it means that you exclude both days. But there's a fair number of time limits that don't use the magic words at least or clear. Where that is so, you don't count the first day, but you do count the last day. So using my exception, if you simply said, in my example, rather 10 days, you serve on the 1st, that day is not counted. Then 10 days will take you up to the 11th, will be the 10th day, and you can have your motion returnable on the 11th. Okay, it can be returnable on the 11th, whereas if you're talking at least or clear days, you couldn't have it returnable until the 12th, because you'd have to have 10 clear days in the middle. Okay. 176 is a helpful rule. It simply says that where you got something that's got to be done by a certain day, and suppose that 12th day turns out to be a Sunday, then you're within your time limit if you make it returnable the next day the court is open, which would be the Monday, or if Monday's a holiday, it'll be the Tuesday, and you're okay. You're within the time doing that. Then, to the eternal gratitude of Maltmans and the Law Society and lawyers generally, you have rules 177 and 8. First of all, any time in the rules, now we're only talking the rules, we're not talking about the Highway Traffic Act with its 2 years and that sort of thing. Those things you can't, by agreement or otherwise, extend. But any time described in the rules can be enlarged or decreased, abridged, by consent of the lawyers acting for the parties. Okay, that's first of all. On consent, any time limit in the rules can be increased or decreased. Consent of all parties. And Rule 178, even if you can't get the other side to agree to it, the court can increase or decrease any time limit, even if you don't get around, as you often don't, to applying to the court until the time limit's gone. The court has the right to increase. And generally speaking, the court is reasonably sympathetic as long as you can show reasonable excuse and not excessive delay on the time limits. So 177 and 8, important rules. 179 really doesn't matter anymore. The long vacation, as it's called, is July and August, Christmas vacation, December 24 to January 6. All that really matters is the courts don't usually sit during those times. All time limits continue to run then, and in fact, even the courts are sitting now during most of those days, so that it no longer means what it used to in the more leisurely days of practice. Rule 201, Rule 202 are important. Remember that documents that start an action have to be served personally unless the lawyer accepts service or unless there's an order for substituted service. But what about all the rest, all the documents later on, after these initial documents? Well, that's where Rule 201 comes in. Rule 201 says you can serve the solicitor of the party with all those subsequent documents, that is to say, with all documents that don't normally have to be served personally, and you can do it by leaving a copy at the solicitor's office. Normally when you do that, you'll have an original copy and you'll have them stamped, and you've all seen this, admitted service, a true copy here of admitted. It's an admission of service, remember, as opposed to an acceptance. Normally they'll do that. Sometimes they just want to be lousy, or the lawyer says, he's giving me a rough time, give him a rough time, don't admit service. No problem, you just go back and you have whoever served it do up an affidavit of service, sworn, saying I served it on the receptionist at Mr. So-and-so, and that gives the same effect, just a little bit more hassle. So you can leave a copy, or as we frequently do, where the people are not in the immediate area of your office, you can mail a copy. But the problem with that is that there's a time limit. Because of the mails, it used to be an unrealistically long time limit, it no longer is, thanks to the Canada Post. 4 days. Things are deemed to be served on the 4th day after you mail them. Now, you got lots of notices of motion and stuff where you're getting kind of late, you simply don't have 4 days to play with. And as a result, you got to go out and serve it personally on the office of the lawyers. But if you've got the time, bang it in the mail, wait 4 days, or if you're in Toronto where they have the Toronto Document Exchange, they've added now that you can, and that Toronto Document Exchange is an approved document exchange, you can use that. In that case, it's deemed to be being served on the next juridical day, that is to say the next court day after you do it. So there's only a 1-day delay doing it by TDX. Okay, that's important, but what about the defendant or the plaintiff who doesn't have a lawyer? because 201 only talks about solicitors' offices and so on. That's 202 then. 202 says there that where you don't have a solicitor, documents except the starting ones, the ones that have to be served personally, can be served by mail in the same way addressed to the address of that person at his home or residence. And again, you've got the fourth day thing. Now, remember 203. Suppose you show up, I guess, at a very small solicitor's office and there's nobody there. So it's a business day, but there's nobody there. You can serve it by mailing it, by registered mail during the same day, and service is deemed to have been carried out on that date. Now, I don't know how often and how many lawyers run a practice where there's nobody there sometimes during the day, but if you ever face that, don't lose sight of that rule. All right. When do you serve? And I should just mention, by the way, Section 132 of the Judicature Act is back on the previous page, and it's an important one from your point of view. Section 132 is part of our old Puritan heritage and stuff. You can't do anything on a Sunday. You can't serve documents on a Sunday. It's void, as if you never served them. You can't try to execute on documents on a Sunday. And it's not just that they're void, but you can be sued. You can be sued for doing it. So Sunday is a no-no. Rule 206, when can you serve documents? When are they deemed to be served? Unless you got an order to the contrary, on Saturday it's got to be prior to 1. If you serve it at 1:05 on a Saturday, the service will deem to be the Monday, unless Monday's a holiday, in which case I guess it'll be the Tuesday. Service, furthermore, is carried out later than 4 o'clock on a normal day, will be deemed to have been served the following business day. So 4 o'clock ordinary days, 1 o'clock Saturdays. Notices of motion, interlocutory, Rule 217, interlocutory ones, that's notices of motion along the way in the action, not the one that starts the action. 2 clear days, remember clear days, so that's going to have to be first, second, third clear, and you have to, the earliest you could bring is the 4th. 7 clear days with respect to an originating notice of motion. We then come down a number of rules which I don't think we have to take a whole lot of time about since we don't have it to take anyway. I think that the 237 motions, setting down motions, normally you have to set them down in the court office the day before the date. But note that in Toronto, if you're bringing a motion in what's now called motions court, and used to be called weekly court, you've got to phone in advance. You can't just pick, and it's the only court, I guess, in which you can't just pick a date and then serve the documents. You've got to phone and get a date from the weekly court office, and then, as soon as you got the date, you plug it into your notice of motion and get it served and filed. And if you don't do that within, I think it's 7 days, if they don't see that notice of motion come into their office with the admission of service or affidavit of service within 7 days of your phoning and taking out the appointment, they cancel the appointment. And if the notice of motion comes in on the 8th day, you're out of luck. You've wasted the money of serving and filing. You get a new day and move again. So that's Toronto Weekly Court. That's Supreme Court Motions Court. That applies, and you've got to be aware of that. And that's 237, and then the practice note immediately below that. Setting an action down for trial is another area you can get in trouble in a way that you wouldn't expect. You deliver a certificate of readiness, wait 60 days, and then you can set an action down for trial. You prepare a record, setting out the pleadings and so on. Rule 248 tells you about that. Then you pass the record, set the action down for trial. That's something you actually do in court. What you then have to do, and there's a time limit on this, is that you've got to then prepare a thing called a notice of trial. And there's a standard form. It's a different one for Toronto Supreme Court as opposed to all the rest of the Supreme Court and the county court, but there's a form, the Durham and Dye or whatever. You prepare that and you must serve that. It simply says, take note this action has been set down, has been set down. You've got to serve that on the other parties within 7 days, I think it is. Let me just check. Or I guess, no, I'm sorry, it's 10 days. Within 10 days of setting it down, you got to get the notice served. You might think, well, I've set it down, I'll just take my time and mail it out, take a week to get around to typing it, and then send it by mail, so you got 4 more days added on. Then you go to file a notice of trial back in court with your proof of service, and they say, well, hold on, you did it under Rule 201, that adds 4 days, you didn't send it until 7 days after you set it down. Too late. Then you have to go and get leave of the court to do that. It's totally unnecessary. It adds cost to your client, time to you. So remember, as soon as it's set down, serve the notice of trial and get it filed. Just the minute you set it down. Okay, then we talk about various things and exhibits and so on. Payment into court, this is something that you can do with Rule 306, 309. All at its effect is that you can pay money into court when you've estimated that, in fact, there's going to be an amount that you may well be found liable for. And as soon as you have paid money into court, you've got to serve a notice on the other side advising them of that. Moving for want of prosecution, there are a number of ways, and 322, 3.4 tell you about moving for want of prosecution. If you're the defendant, you reach a point where you're fed up with the thing, it's not being advanced. Well, the first time you can do that is when a statement of claim is not being delivered within the time limited under Rule 43. You can move at that time to dismiss the action for want of prosecution. You can furthermore do it if you're talking in Toronto, where the action has not been set down for trial within 6 months after pleadings being closed. That's Rule 323. Now, that is something that you'll often find is useful, because if the plaintiff isn't getting on with discoveries, you can find that, generally speaking, it's at least 6 months have passed since pleadings before you're getting concerned about it, because it takes that long normally to get pleadings on. Well, you threaten them and say, let's get on with discoveries, and he says, well, I'm not ready to and stuff. You can move in Toronto as soon as 6 months have passed from the time the pleadings have closed. And outside of Toronto, you can move as soon as 6 months has passed from the time at which, unless the plaintiff has set down the action at the first sittings after the 6 months, after 6 months has expired. Because you've got to remember, outside Toronto, they don't have constant court sittings. They only occur every so often. So that's a useful weapon to have when the discoveries just aren't getting on in your year, 2 years into the action, and you're looking for your lever on that. 323 is the one that you rely on to dismiss the action for want of prosecution to get it ahead. We then talk about discoveries and so on. I think the time limits there are reasonably straightforward. They're set out as I put them in the rules. We get up to 497 and through 498, 9, 500. That's all appeal stuff. You've got the time limits there, as I thought you should have them there, but you're going to be hearing about them separately in the next lecture, and I don't want to repeat all that. Let's go over to Rule 760 on page 24. It is still thought by many secretaries and lawyers that where you're dealing with a court office out of town, where you live, in a different town, you have to pay a local law firm to file all your documents at the court. And that is a waste of money, because they'll charge you $15 or $25 to do that. Many people still do that. It is unnecessary for most matters. Not all, but most. Look at Rule 760, the things that you can simply send along a copy. Let us say you've got a piece of litigation going with a firm in Hamilton. You will serve them normally by mail, because you're not going to want to go over to the lawyer's offices in Hamilton. You send off the statement of defense by mail. You do up your affidavit of service by mail. And the first thing to remember is you can't file with the court office anything served by mail until the 4 days have expired. They will not accept it until that 4 days has expired, because it's not deemed to have been served until then. So you'll wait maybe 3 days, then you can simply mail the original statement of defense with your affidavit of service, mail it to the court office in Hamilton. You just mail it there with a nice little letter saying, here with the statement of defense with affidavit of service, and next there too, would you kindly file this on our behalf? I thank you for your assistance. There's no fee for that particular service, so that you don't have to send any money along, and boom, you've got it. And that is something that you can do by mail. It's cheap, it's easy, but never ever trust the mail. So make sure that you phone the court office a week or two later and just check the file to make sure the thing arrived, because they aren't going to acknowledge it. They're not going to write back and say thanks for your letter. They have better things to do. So you've got to check. It's a very useful way of doing this, and there's other things you can do, and they're listed down here of all the things that you can file. You can file an appearance by mail, send along the appropriate check. But again, you've got to make darn sure, particularly if you're dealing with something like a specially endorsed writ, where you're sending along an appearance and an affidavit of merits, you want to make darn sure it gets there. Because if it doesn't, then you're going to be obviously in a problem. Hopefully, you'll have sent one as well to, of course, the lawyer who is acting for the plaintiff in that case. Well, hopefully one of those letters will got through, and if either one gets through, you're pretty well covered, because if the lawyer for the plaintiff gets one, he's not going to think that you haven't filed it, so he's not going to bother to go ahead. And if the court gets one, the plaintiff's lawyer goes running down there to nail you, and boom, there's one sitting there in the file. But still, do check with the court office. It's important. But see all the things in 760 you can send by ordinary mail and save yourself the $15 or $25. There are some things you can't do, such as setting an action down for trial. That has to be done in person at the court office. Don't ask me why. That's simply the way they're doing it. Still, it'll change, but it hasn't yet. There you will have to get a local agent, simply show up. You'll send him or her the record and just ask them to show up, and they get the file. It's the action set down for trial. Equally, things like praecipiing matters, generally speaking, where you have to praecipy things for security, for costs, and that sort of stuff, it has to be done in person. That will change in due course, but it hasn't yet. Finally, Rule 770, you knew it, but you've probably wondered where it said so. The rules of practice apply to county court as well, save for minor things where they're talking about specific weekly court and so much doesn't exist in county court. My time is just about up. Just a couple of things I was given that really don't seem to have anything to do with time limits, but they're here. Approval of orders. Where there's been a motion brought with opposition from one side or the other, An order is obtained, it's drafted up usually by the party that is successful on the motion. Before you can get it signed, issued, and entered, you have to send it to the lawyer on the other side and get him to write. He simply writes on the bottom of it, approved as to form. Some of the so-called purists say you're supposed to say approved as to form and content, but since the court office doesn't care, there's no reason why you should. Approved as to form, McCarthy and McCarthy, solicitors for, and you have to say who your solicitor's for. Then you send it back to the plaintiff. Sometimes people won't approve it, in which case what you have to do is go ahead, get an appointment in front of either the master, if it's a master's motion, or the clerk or registrar, if it's a motion of a judge. And you both have to show up and argue over what the judge or whatever meant when what the order should actually be. You shouldn't have to do that. It's a Mickey Mouse way to practice, but some people are just like that. But generally speaking, you'll just get it approved as to form. It must be approved as to form before the court will, in fact, permit it to be signed, issued, and entered to become a binding document. Accept versus omit, we've talked about service by mail. We've talked about both, so you can have substituted service of the original documents, and then under 201 and 202 you can have service as well. Where to issue writs, the court office, and so on. Service under the Evidence Act, there are certain sections of the Evidence Act which provide for expediting evidence of business records, which includes hospital records and so on, and of medical reports. Section 36 of the Evidence Act is with respect to business records, Section 52 with respect to medical reports. In each case, if you want to file these documents without having to call every single person who wrote every single entry, you can give a notice in advance, 7 days in advance in both cases, 7 days in advance. It'll be advance of trial is when it'll normally be relevant. And you can then just call a single witness who will say, yes, I'm the records librarian for this hospital. This great big thick document is the chart kept in the ordinary course of business by all the people who are named there. And then it goes in as evidence with appropriate weight determined by the judge without having to call every single nurse and doctor who wrote an entry on it. And that's, as I say, those two things. That's service under Evidence Act. Notice of trial we've talked about. That's all there is, there ain't no more. Thanks very much.
Thank you very much, Michael. Oh. We're all witnesses. Now, if you can figure out some way of putting that on a slide rule so all of us can refer to it very easily, you'll be a magician. We're going to adjourn for coffee now. We'll be back in exactly 15 minutes, please. Excuse me, ladies and gentlemen, could we have your attention, please? We do have a lot still to cover, and we'd like to get on with the program, please. I know that a lot of you have things that you want to do on Saturday afternoon, and we don't want to keep you much after 1 o'clock if we can avoid it. We'd like to go on with the program, and at this time call upon Mr. Ian Blue. Mr. Blue is going to speak to you on court motions. Mr. Blue originally was called to the Alberta Bar in 1970, subsequently to the Ontario Bar in 1974. Since 1976, Mr. Blue has been associated with Castles Brock, and his practice comprises of work in civil litigation and administrative law. Mr. Blue.
Good morning. I've been giving 15 minutes to talk to you all about motions. If any of you have seen my material, it's about 50 pages thick, well, really 42. I don't propose to read every word in it. What I'd like to do is two things. I'd like to take you very briefly through the material that I file, then I'd like to make some salient points about motions. In the paper that you have before you called Court Motions, I've used a question and answer format. I did that because all the questions that I posed had answers which were unknown to me before I set my hand to doing this motion. So this was a voyage of discovery. The second thing that the paper has is notes. So you'll see all the little footnotes throughout the text. That'll refer you to the notes. And the notes take you to the rules or to the practice directions which I'm relying on for the statements that I make. Also, there are 3 appendices. The first appendice contains what I consider to be the applicable rules which should be known to you as legal secretaries as well as the applicable practice directions. So I've taken those out of Chitty's rules of practice and set them out there for your convenience. I have not set out all the rules about motions because most of them I don't think you need to worry about. I've set out the ones that I think you should know. The Appendix 2 contains precedents. The precedents I've set out are a notice of motion and an order, which are in the proper form for the master, a notice of motion and order, which are in the proper form for motions court, a notice of motion and order, which are in proper form for county court, and finally, a precedent for a record, and a precedent for a memorandum, or I should say a statement of fact and law required on a motion. Appendix 3 is a one-page document. It's a document that doesn't appear in the rules, but nevertheless is important. It is the form which the senior master uses as a request for special appointment. So that's the material. Now I wanted to say a few words about motions. And really, I always think of going to motions court, be that in county court, the master, or motions court formally, as a lot like love. You can read about it, you can be told about it, you can imagine it, but you don't really know what it's like until you experience it. And the reason I say that is that before the master or in county court, you have turmoil. It is sometimes like a scene out of Dante's Inferno. It starts at 9:30, at 10 o'clock. The room is small. There is probably not enough seating space for all the people that are there in wintertime. Coats are piled over chairs. The temperature of the room goes up with all the bodies in the room. People are nervous. And then at the appointed moment, the judge or the master appears. He has a mound of files about 16 thick. It's obvious that he hasn't been able to read them all. It's obvious that he has only the basic understanding about them. You learn very quickly that the master or the county court judge or sometimes the motion court judge will take the line of least resistance on a file, and he will refuse to hear it on what the lawyer thinks is the most ridiculous ground, but which he is entitled to do under practice, under the rules of procedure. What follows from that is that when you're doing motions or preparing motions in the office, they must be done perfectly. They must be done in a way that even the most picky of masters can find nothing wrong with them. Your paper must be in perfect order, because your lawyer, when he goes to court, if he's either opposing a motion or bringing a motion, wants to worry about the merits. He does not need a cranky master or a cranky county court judge or a picky opponent pointing out that his document is in the wrong form, that it was served too late, that it was brought in the wrong place, or that the right material isn't brought. So your duty as legal secretaries is to make sure that the paperwork for a motion is in order so that your lawyer does not have that kind of difficulty when he goes to court. Now, he must take responsibility too, of course, but you should have good precedents. You should know the rules yourselves to take that burden off his shoulders. Now, Adeline asked me to talk about a number of points, which I will try to do briefly. The first is, what kinds of motions are there? Well, I think Michael Royce made the point. Motions are two kinds. There are originating notices of motion, and there are interlocutory motions. The names bear a similarity. The form of document is similar. They are two quite separate things. An originating motion, for your purposes, is exactly the same species of document as a writ, especially or generally endorsed writ, or a divorce petition. It is a document that commences an action. It is a way of getting into court for the first time. You have to open a court file for an originating motion the same way you do when you issue a writ or a divorce petition. On the other hand, interlocutory motions are motions brought in the course of proceedings. You may bring an interlocutory motion in a divorce action commenced by a petition, or any proceeding commenced by a specially or generally endorsed writ, or even in a proceeding commenced by another originating notice of motion. Now, in my material, I've set out in detail how one goes about arranging a motion and setting it down in Toronto, and I'm not going to repeat that. I've set out when the motion must be served and when the notice of motion must be served and filed. But the next point I wanted to cover is when is and when is not a record required. All right. The applicable rule governing records, and just note this, that's all you have to do is one number. The only rule I'm going to refer to this morning is Rule 238. The effect of Rule 238 is that a record, as defined by that rule, and a statement of fact and law must be filed in all motions brought in motions court. All motions brought in motions court. A record is not required before the county court of the master, but it is required in all motions brought in motions court. Now, what does a record contain? And this is an important point. Rule 238 sets 1 says that the record should contain an index. It should contain the notice of appeal or the notice of motion. You have to set out the order that you're appealing from and reasons for judgment of any. And then the rule says, and this is important, such other material as is necessary for the due hearing of the motion. Well, you ask yourself, what is the other material? Well, that's a matter of judgment. You must consult with your lawyer about that. But the important thing to remember is why a record is required. And the reason a record is required in motions court is because the judges have gotten sick and tired of having a full court file about that thick of unorganized documents. So what happens is that in the motions court, the weekly court office prepares for motions court a special motions court file. And the only thing in that motions court file are the documents placed in your record, if you were the applicant, or the documents that will be placed in the supplementary record if you were the respondent and want to file a supplementary record. The judge has nothing else. So a lot of attention has to be given to what additional documents go in. You may want affidavits from other interlocutory motions. You may want transcripts of cross-examinations. You may want orders from other proceedings or other material. Ask your lawyer about that. Draw his attention to that rule and say, what other material do you want? And make sure that it's included. Now, you also have another option, which I've talked about briefly. You are entitled to precipice other documents from other court files and have it included in the motions court file, and not include them in the record. But if you're going to do that, give yourself plenty of time to order those from the applicable court office or from the special examiner or wherever they come from, and make sure the day before the motion is to be argued that you phone the court office or have a student go over and check it to make sure that the document is properly filed. Then and only then will you be sure that the judge has before him everything that he needs to hear your motion. If you don't have the material there, the judge throws up his hands. If he's a nice judge, he'll adjourn your motion, your lawyer's motion, to a date to be fixed by the registrar, and all you have to explain to your client are the costs of the second motion. If he's a mean judge, he'll dismiss the motion, and then you're really in the swamp. The next point I want to deal with, and I don't want to take too long, is the form of notices of motions and orders. Well, just a minute, one prior point before that. Statements of fact and law in the motion. Remember this. A statement of fact and law must be filed in motions court wherever a record is filed, except where what you are bringing is an appeal from a master's order or taxation. But so the general rule is you must file a statement of fact and law. Question? Well, where is the format of that statement of fact and law set out? Answer, it isn't. What we do in our office, and what I think most counsel do, is adapt the form of appellant statement in the appeal provisions of the rules. I have set out the headings that you should follow in my paper. But just be aware that you're not going to find a prescribed form for that statement of fact and law, yet you are expected to have it in the form that I've set out there. Now let me come to the proper form of motions to finish off. Those of you that were in practice prior to 1978 probably are aware that we used to have in Ontario things called chambers and things called court. That existed at the Supreme Court level. And the form of documents differed depending on whether the motion was being brought in court or in chambers. That distinction was abolished in 1978, and with it was abolished the difference in format. So I want to leave you with one piece of information, and that is that now the proper form of motion is Form 39. If you follow the opening words in Form 39 to the rules of practice, you are never wrong. And it says, take notice that a motion will be made to the court, the master, or whoever, and it is not, and as I emphatically stated in my paper, repeat not, take notice that an application will be made. Application is passé. Application has gone the way of short skirts and wide lapels. Now, be careful of that, because two people, you may have old precedents in your precedent books that have that form, forget them. The other thing is that several of the forms and the rules of practice that are for special proceedings, like a motion for particulars or whatever, still have take notice that an application will be made. In my opinion, that's wrong. What happened was they forgot to amend those forms when they amended the general form 39. I'm telling you, and I've checked this with the court office, so we'll get no hassle. You will not be wrong if all your notices of motion are in the Form 39 that say take notice that a motion will be made. Okay. Now, having done motions, let's talk about orders. At the same time they amended the form of notice of motions, they amended the form of orders, and the proper form for orders is now paragraph 1. It is ordered that, not this court doth order. This court doth order finally died the death that the English used, and it died about 1700 for orders. So the form is, it is ordered that, it is further ordered that. And I've set that out in my paper. Now finally, I draw your attention to the fact that in my paper I have put some information about what you should know about consent, ex parte, and unopposed motions. And I've set out the procedure to be followed for motions court, county court, and the master. I've done the same thing for consent matters. And I'm asked to pass on to you, with respect to the master, this information. That if any motion that has been set down appears, if it appears likely that it will go by consent or it will be unopposed, and you didn't know that when you set it down, phone the master. Phone the master anytime until 9:30 in the morning the motion will be argued. Find out who the master hearing the motion is. Speak to him. He gets very cranky if he comes to motions court having read the file and finds out that he didn't have to. He's a very busy man. So the practice is phone in anything that will go by way of consent or be unopposed as soon as you know about it, no matter how late, up until 9:30 in the morning the day will be motion made. I think that's all I can usefully say in 15 minutes, Adeline. Sorry I went a little bit longer, but thank you very much for your attention.